While a person must usually have mental capacity to make a valid will in England and Wales, known as testamentary capacity, under Section 18 of the Mental Capacity Act 2005, where a person lacks that capacity to make a will, it's still possible to make what's known as a statutory will by application to the Court of Protection. The court will consider a number of factors when looking at whether or not to make a statutory will. Statutory wills are often appropriate where a person's previous will might not reflect a change in circumstances, for instance where a beneficiary's died or an asset's been sold to pay for care fees, where there's no previous will and the strict legal rules, known as the intestacy rules, perhaps aren't appropriate or suitable, or as is often the case where there's been some form of personal injury or medical negligence and the person's received a significant sum of money. The court will need to consider a number of factors, including whether the person in fact has mental capacity to make a will, that person's past and present wishes and feelings, and the views of any relevant third parties. This can sometimes lead to a divergence of views, and where there's any disagreement about the terms of any proposed statutory wills, parties then have the opportunity to raise any objections. These objections are often set out in detailed witness evidence. In that case, the Court of Protection will usually hold a hearing to listen to the varying views to determine and decide on the terms of any such statutory will. The usual rule in such cases is that the costs are paid out of the person's assets. However, more recently, the court has departed from that rule where parties have acted unreasonably.